Okay, great. So thanks everyone for joining today's webinar. Just before we begin though, I'd like to start by acknowledging that I'm speaking to you all today from the land of the Gadigal and Wangal people of the Eora Nation, and I'd like to pay my respect to elders past and present. So today's webinar will be covering the process of navigating the NDIS and what you can do if you're not satisfied with a decision by the agency. Now, before we begin though, I might just get some housekeeping out of the way. Number one, the webinar is being recorded as well as being live streamed on our Facebook page on Your Story Disability Legal Support. We also have Auslan and captions available. So if you want to turn that on while on Zoom, you can go to the bottom of the screen in the toolbar and click on the button that's labeled CC Live Transcript. If you're having any issues with that, please post in the chat and one of our colleagues will try to help you with that. And finally, if you do want to ask us questions, we do have a section at the end of our webinar where we will try to answer those. On Zoom, if you could use the Q&A function and not the chat function to ask those questions, that would be great. You can choose the option to ask the questions anonymously as well if you wish to. On Facebook, if you're watching through the live stream, could you please post your questions in the comments? And look, if we don't happen to get to your questions by during that webinar portion, we will respond, or we will try to respond via email. So without further ado, our speaker today is Dominique Brown, who's a solicitor for legal aid in the NDIS appeals team. And prior to work in the NDIS appeals team, Dominique worked as a general civil solicitor at Legal Aid and also as a disability advocate. So I might just hand it over to Dom.
Thanks, Peter, very much for that introduction. I first would like to acknowledge that I am speaking today from the Gadigal land of the Eora Nation and pay my respects to elders past and present. Thank you everyone for coming to this webinar today, and hopefully there's some really valuable and helpful information in it for you or the person you support in navigating the NDIS. What we are going to cover today is an outline of the access criteria to become a participant in the NDIS, reasonable and necessary supports, so what reasonable and necessary means and what the NDIS will and won't fund. We're also going to cover preparing for scheduled plan reviews, when and how the NDIA must make decisions and what to do when you don't agree with their decision, and NDIS matters in the AAT, tips to help prepare your case. So we have seen, as people have been registering for the webinar, that there have been questions coming in around how to approach doctors and medical experts for information when you're in an NDIS review process. And that's something that we're going to cover today, as well as types of support that might be available for people with mental health disabilities, and as well who can support you during a appeal in the Administrative Appeals Tribunal. So we've seen those questions, and again, as Peter mentioned, there's some time at the end for questions too. The first thing I just wanted to go over was a bit of terminology, just so I guess as we go through, we might be throwing around some language that some people may not be familiar with. So the NDIS is the scheme which provides funding directly to people with disabilities. It has its two parts. There is a part which provides information and community linkages for people with disabilities that aren't necessarily participants. And then there's a second part of the scheme which provides plans and supports to participants. The NDIA, as distinct from the NDIS, is the agency that administers the scheme. They make decisions about whether someone is eligible to be a participant, and if so, how much funding they receive. Participants are people who apply and meet the access criteria for the NDIS. A support is assistance or products, so that could be equipment, it could be a type of aid, or some technology that help a person to complete everyday tasks and to work or to participate in the community and reach their goals. When I refer to the law or the Act, I'm referring to the National Disability Insurance Scheme Act. And another word that gets popped up around a lot is a functional assessment. And that is an analysis of a person's functional performance in everyday activities in their home and in the community. So often that looks like an OT coming to your house and asking you to do certain things and demonstrating how you might use different areas of your house or how you might access the community. And there might be some differences in the type of assessment for psychosocial disabilities that can help provide a picture of your functioning over time. This is just an outline of the NDIS journey. As you can see here, it's a continual process that the participants go through each, I guess, period of their plan review. So some people have different lengths in their plans, but essentially it looks at your goals, and then from your goals, an NDIS plan is built. Then that plan is managed and spent over however long it's in effect. And then there's a scheduled review and you recommence that process again. So the first thing that we're going to touch on is accessing the NDIS. And on screen now, I've got the access criteria. So the starting point is Section 21 of the NDIS Act. And that outlines the age requirements, which is a person needs to be under the age of 65 when they apply to the NDIS. You can remain on the scheme after the age of 65, so long as you made that application before you or the person you're supporting turned 65. The residence requirements is that you or the person you support must reside in Australia and either are a citizen, a permanent visa holder, or a special category visa holder who is a protected special category visa holder. The next two is that you can either meet the disability requirements or the early intervention requirements. And I just wanted to note, as you see down the bottom there, disability isn't a defined concept in the NDIS Act, and neither is impairment. So it what it indicates is that the NDIS isn't concerned about how you came to have a disability. It's looking at how that disability may have an effect on your life. One other area that I did just want to note as well is sometimes we get a lot of questions about recognising primary and secondary disabilities, and that isn't something that's in the legislation. We know it's language that can get used, but it's not something that's in the legislation. So if you have information about a disability that you'd like the NDIA to consider, we recommend providing it. So the disability requirements are on the screen, and this is drawn from the legislation. And so it looks at whether a person has a disability attributable to one or more intellectual, cognitive, neurological, sensory, or physical impairments, or to one or more impairments attributable to a psychiatric condition. Those impairments need to likely to be permanent, and it needs to substantially reduce your functional capacity to undertake activities in either communication, mobility, social interaction, self-care, learning, or self-management. And it just needs to be one of those areas. It doesn't have to be all 6 of them, just at least one of them. It also needs to affect your capacity for social or economic participation, and the person is likely to require the support of the NDIS for their lifetime. So in relation to these criteria, issues that we often see are around treatment. There's a difference, I guess, between treatment that is likely to remedy an impairment or treatment which is more ongoing care, maintenance, and preventing decline. So that latter example, so ongoing maintenance and staying engaged with medical practitioners for that purpose, an impairment can still be permanent, but if there's still treatment that might remedy an impairment, that may not be considered permanent. The other, I guess, big issue that we see in relation to the disability requirements is around fluctuations and impairments that might vary in intensity. So those impairments can still be permanent, and the assessment of whether a person has substantially reduced functional capacity should look at functioning across the whole spectrum of a person's life. And I'll just go, so the next slide is the early intervention requirements. And they are, again, you can either access through the disability or the early intervention requirements. And it looks again whether a person has an impairment that is an identified intellectual, cognitive, neurological, sensory or physical impairment that is or is likely to be permanent, or they have an impairment attributable to a psychiatric condition that is or is likely to be permanent, or a child who has a developmental delay. And the CEO needs to be satisfied that providing early intervention supports will benefit that person by reducing their future need for supports in relation to their disability, and that the intervention is likely to benefit the person by either mitigating or alleviating the impact of that person's impairment on their functional capacity, preventing the deterioration of their functional capacity, improving their functional capacity, or strengthening the sustainability of informal supports available to the person. And the final criteria is that the support, the early intervention support, needs to be most appropriately funded through the NDIS. The other, I guess, part of the legislation that a lot of focus is paid onto is the reasonable and necessary supports. So reasonable and necessary is a phrase that comes directly from the legislation, and it is a section in the Act, section 34, and what it says is that support will be reasonable and necessary if it assists the participant to pursue their goals, objectives and aspirations, as in their statement of goals and aspirations, that it will assist the participant to undertake activities to facilitate their social and economic participation, that it represents value for money, that it is or it's likely to be beneficial, that it takes into account what is reasonable to expect family, carers and informal supports and the community to provide, and also that it is most appropriately funded through the NDIS. So that's what reasonable and necessary means. And when you or the person you support receive an NDIS plan, after you've gone through that access criteria, it will include a statement of participant support, and that is where it will outline your general supports and your reasonable and necessary supports that are going to be funded in your NDIS plan. The statement of participant supports as well, just for completeness, also includes the date that your plan needs to be reviewed and how the funding and other aspects of your plan are managed. So these criteria is really important because every support must meet the reasonable and necessary criteria. And it's, I guess, a complete list. You have to meet all of these criteria that you see on the screen at the moment. To assist, I guess, interpreting and understanding what these criteria mean, there are also NDIS rules, the NDIS supports participant rules, that provides some further explanation around how to satisfy these criteria. There was a few questions I know about things that the NDIS can and can't fund, and a lot of that is drawn from whether something is most appropriately funded by the NDIS or whether it's something that might be available through a general system of service delivery or a universal service obligation. So here, I guess the areas that have crossover or some things might be funded by a different service system, those kinds of systems include health, housing, justice, education, workplaces and transport. So that's, that went a bit too fast, what is referred to there as those other types of systems. So examples of supports that are available under the NDIS, there are things that will assist you in daily care, help with household tasks, and help, so they can also include funding for transport, which enable participation in the community, It can include access to therapies. I've just given 3 examples there, but other therapies as well can be accessed. It can include modifications to a person's home or their vehicle, and it can also include coordination of support. So they're the types of things that the NDIS can fund. Generally, what is not available under the NDIS is supports that are not attributable to a person's disability. And there are, in those NDIS support rules that I mentioned before, there are some rules around, I guess, generally when a support can't be funded. So that might be that if it's likely to cause harm to a participant or pose a risk, that it's not related to the person's disability, that it duplicates another support delivered through the NDIS already, or it relates to a day-to-day living cost. And examples of that could be rent, groceries, or utility fees that aren't attributable to that person's disability. And support that won't be funded is support that consists of income replacement. In those areas where there might be crossover with another service system, so such as the health system, I've given some examples on the screen, such as diagnosis, assessment, and treatment of health conditions, GP, specialist, surgery, hospital, post-acute care, palliative care, and medication. They're things that sort of fall under the health banner. Dental, again, is not something that's available under the NDIS. And in relation to mental health, so supports that are residential care when the purpose is for inpatient treatment or clinical rehabilitation, that won't be available under the NDIS. In an education setting, supports for students that primarily relate to their educational attainment, so things around teaching, learning assistance, but also school building modifications won't be funded by the NDIS. The NDIS also doesn't fund homeless specific services or crisis accommodation for people in need of housing. And the NDIS won't be responsible for the accessibility or making public transport accessible. The other important aspect in terms of when a person receives, or the person you support is receiving their NDIS plan, there are different types of ways that those funds can be managed. So the options are NDIA managed or agency managed, and that's where the agency will pay providers on your behalf. The other option is plan management, which includes you'll receive funding in your plan to pay a plan manager who pays the providers, keeps track of funds, and takes care of financial reporting. And the other option is self-management, and that is where you manage your NDIS funding, and it gives you flexibility and choice around what supports that you purchase to pursue your goals. The other option is you can have a combination of the 3 options, and that's not uncommon to see. So there might be some aspects of a plan that are self or plan managed and other parts that might be managed by the agency. So you can have a combination there. I also just wanted to touch quickly on nominees under the NDIS. A nominee under the NDIS, there can be either a plan nominee or a correspondence nominee. A plan nominee is someone who is able to do things that relate to the preparation, review, or replacement of your plan and the management of funding under a plan. And the correspondence nominee does things that aren't to do with the preparation, review, or replacement of a plan or the management of funding. So often they are a person that receives your correspondence and the agency will contact for you. So they're the 2 types of nominee. Nominee appointments aren't particularly common, and they do come with a lot of provisions around the obligations and the duties of the nominee in relation to the participant. And so the duty of the nominee to a participant is to ascertain the wishes of the participant and to act in a manner that promotes their personal and social well-being of the participant. And when the agency is going to appoint a nominee, they must take into consideration the wishes of the participant making that appointment. You can have more than one person, and a person can be both your plan and correspondence nominee. There can be also limits placed on the time or the types of function that a nominee can do. And there are also ways in which the Act sets out for a participant to change or revoke a nominee appointment. And that's a type of decision that can be reviewed, and we're going to jump into that in just a moment. So scheduled reviews are the review that comes, I guess what we say is at the end of your plan, but it's in your plan, there will be the date by which it must be reviewed, and that's what's referred to as your scheduled review. And it involves a review of your goals. And so at this point in time, it's really helpful to think about your goals, whether they still reflect what you would like to get out of your NDIS plan, or whether there are new things that you'd like to include to work on under your NDIS plan. It's also important to prepare end of plan reports. And most practitioners, I think now with the NDIS operating for a bit now, sort of are in the process of, or have a process to prepare end of plan reports. But what those reports really is helpful to focus on is what so far has been implemented in terms of the supports and what they recommend for the next year going forward. So really specific recommendations help, and detailed on what the goal of that therapy, intervention or support is will help it assist to meet those reasonable and necessary criteria. Another important consideration is looking at how effective your previous plan might have been. And that includes whether any areas that your funding was used up really quickly. So that's probably somewhere that you would want to provide more information about what that support is, how it benefits you, and why you need to access it more frequently than it was previously funded. You also then, I guess on the other side, look at, were there any areas that you may have had funding remaining? And you may need to provide information that explains why there was remaining funding if you want to keep that same level. So for an example, in the last couple of years, you may not have accessed a certain support as often as you usually would have because of all the lockdowns we've been having. And now that those lockdowns are ending, you may be looking at accessing that support at a higher rate than you did in the last plan. So just providing the agency information as to why there's leftover or surplus funding in your budget at the end of the period. And the next area is on the review rights for the NDIS. So the first type of review is what we call an internal review, and that's done by the NDIA. And types of internal reviews are, decisions that you can seek in internal review are if you don't meet the access criteria, if you don't agree with the level of supports in your plan, if you have made a request for a plan review and that's been denied, and nominee appointments and cancellations and suspensions are also reviewable. The time limit for applying is 3 months from when you receive notice of the decision, and the NDIA need to make a decision within 90 days. The second type of review is it's called an unscheduled plan review, and that's something that you would request after the first 3 months of your plan. So the first type of review, the internal review, may be that you get your plan and it's not quite what you're expected, and then you seek a review to have either the funding adjusted or something included that wasn't. Whereas an unscheduled plan review, you might be further along in your plan, and you or the person that you support, there's a change in your circumstances around your living situation, or there might be a new piece of equipment that you require. You can ask the agency to review your plan ahead of the review date. The unscheduled plan reviews are discretionary, so the agency can decide not to do the plan review, but they need to make that decision about whether they're going to do it within 14 days. And if they do decide to do the review, they need to facilitate that within 14 days of deciding. With both those types of reviews, providing new information to the NDIA is beneficial to help them understand the decision that you'd like them to make. For an internal review, there isn't a prescribed form or format, but there is a template form available on the NDIS website that is quite helpful in setting out the types of information that the agency might need to help them consider that decision. And they are, in both instances, required to provide notice of their decision in writing to you. And finally, if you do receive a decision that you're not happy with or that you don't agree with, the next place to take that is what we call external merits review within the Administrative Appeals Tribunal. And the time limit to apply for that is 28 days. There we go, it wasn't skipping along. So now we're going to cover the Administrative Appeals Tribunal, or the AAT as it's often called. So the process of the AAT, there will be case conferences. And so that's a meeting generally by phone. Some of them are by video, but it's generally by phone between yourself and the person that you support, and the registrar at the AAT and the NDIA will have a representative who's there. They're confidential. The most important thing, I guess, to note is these aren't a hearing. You won't get a final decision on your matter generally in the first case conference. They're a time to discuss steps to move the matter forward. Conciliations, usually after you've had usually about 2 case conferences and sort of everyone knows what the evidence is and the evidence being put forward, conciliation is a confidential meeting with the registrar, again, the agency's representative, and you sort of mediate on where that you might be able to find agreement to resolve a matter. And generally it's just in supports matters that you will hold a conciliation. Hearing is if you haven't been able to resolve it in those case conferences or at the conciliation. It's public and it's before an AAT member. So that's someone who is a decision maker. Both sides will set out their case. The tribunal will receive evidence from applicants and experts. And usually in a hearing, the decision's reserved and it's published at a later date. The other process that you might be involved in the AAT is what we call either a directions or an interlocutory hearing. These are processes that are scheduled as needed when parties aren't able to resolve a type of issue that needs to keep moving the matter forward. So that might be a question around going to an assessment or a jurisdictional issue, and they're sort of scheduled ad hoc. In the registration for the event, we noticed there were some questions around who might be able to support a person in the tribunal and whether, in particular, support coordinators are able to attend tribunal proceedings. And I guess the thing to keep in mind is in the AAT, different people will have different roles, and people that who support you through your NDIS plan may be people that later can assist the tribunal through giving evidence, and it could be perceived as a conflict for them to attend those dispute resolution conferences or conciliations. However, some people, that's the only support they have through the AAT process. So it might be that they wish for that person to support them, but it'll just be about bearing in mind whether that's someone who is later going to assist the tribunal through their evidence. Evidence in the AAT. So I've got on screen the 5 different kinds of evidence that are often used. So medical reports to help, I guess, understand the nature of a person's impairment, and if it's an access case, for example, the treatment that's been explored so far. Functional assessments and information are really valuable, as well as personal and carer statements. And often there is a role as well for research around an impairment. With evidence, it helps if the reports are as comprehensive with as much detail as possible. If you're not sure about what evidence that you may need, one, I guess, trick or tip is to look at the criteria that you're trying to satisfy. So if it's an access case that you're involved in, or the person you support's involved in, looking at either the Section 24 disability or Section 25 early intervention requirements, and using that as a checklist, sort of going, have I got something here that addresses each of the criteria here? And then the same if it was a support one, looking at what Section 34 says, okay, have I, able to address something in relation to goals, socioeconomic participation, and so on. There's also information available on the NDIS website. They publish guidelines about information that they think will help them to make decisions. A big tip is to focus your evidence on the issues. So for access matters, things that will confirm the diagnosis and the permanency by a qualified specialist, providing a history of the treatment that's been undertaken, if there is future treatment, what the purpose is of that treatment, providing information around functional impairments. And that can as well be somewhere where a carer or a personal statement can be really helpful, because that kind of gives a better picture over time as well about how a person may be impacted in their day-to-day life. Looking at risk factors in terms of what is the risk to this person if they're not provided with support, and that ties in then, how is this support needed, or the scheme going to assist that person going forward. In support cases, specific recommendations around the type of the support, the level that support's to be provided at, and the frequency are really helpful for the tribunal. Explaining why that support is being recommended or required. So, is there a risk of harm to a participant if it's not provided? Is there a risk of deterioration or decline in that person's physical or mental well-being if support's not provided, as well as then the benefit that a person might experience from being provided that support. The goals, aims, and purpose of the intervention or support. So is it going to increase functionality? Will it increase independence, maintain health and well-being? Will it facilitate community participation, or assist someone to participate in activities that are of a social or economic nature? So providing some context about how this support plays into a person's life. And information about alternatives includes what costs of alternatives might be, whether they're going to provide the same outcome, or are there other sources for providing that support. That's, I guess, the content side of it. And so I just wanted to touch on now who might be able to assist if you have any questions around the NDIS. So I've got Legal Aid New South Wales contact information up there. That's the organisation I work for, and for New South Wales, that's, I guess, the Legal Aid Commission. Each state and territory have their own Legal Aid Commission providing NDIS support. The Law Access New South Wales is a helpline that people can ring, and that will connect them with information that they might require around the NDIS. And disability advocates are another really valuable source of support who can assist. So Legal Aid in New South Wales, we provide support to people who are in the AAT process. Disability advocates often can provide support at an earlier stage. And the way that that website works is you pop your postcode in, and it will bring up, as well as the legal aid commissions for your relevant state or territory, disability advocates that might be available to assist you. The Quality and Safeguards Commission is the avenue for if you have complaints around your provider or the type of service that you're receiving under the NDIS. That's the avenue in which to pursue that complaint or get information about that. And on the Quality and Safeguards Commission, the NDIA's website, they do have information around service agreements and forms that might help you when you're engaging with a service provider. The other resource there is the ACCC, which is the consumer, peak body, and they now have resources available for NDIS participants because of the way the NDIS is. You're now engaging and purchasing the services. That has created, a range of consumer rights. So the ACCC has some information about those particular rights, and each state's legal aid commission as well. They have a consumer as well team, and they can handle with those consumer complaints, which is less around the AAT, but about if you have a difficulty in the relationship with a service provider. And I'll just throw it back to Peter now, and he'll explain your story information.
Brilliant. Thanks so much for that, Dom. So we're just moving on to the Q&A portion of our webinar today. And I can see that we've received quite a few questions in the chat. So the first question I might direct to you, Dom, is one member of our audience has mentioned that a lot of the communication that she's been having with the AAT and the NDIA have paused following the outcome of the federal elections. And her question to you was whether cases at the AAT are affected by the outcome of elections and a change in government, and whether the NDIA is in a transitional phase at the moment because of that, and whether that would affect her appeal at the AAT.
My advice would be just to proceed, as if things weren't changing there. So your case is still before the AAT, and the AAT is still going to want to know either information about your disability if you're looking to access the criteria, or the support. So it's still going to want those different types of evidence that we went through in the slide. So my advice would be proceed as you were, and if there is any change the agency are going to make, you'll be advised in due course in your proceeding.
Sure. Thanks for that, Dom. We've got a few more. So another member of our audience has asked, if a person doesn't have the capacity to get onto the NDIS because they don't know it exists, then how would they end up being covered for supports? And can they get on the future if they're not represented?
So in terms of the person doesn't have capacity, it might be that they have a person around them. That could be a family member, it could be an appointed guardian, or if they are residing in a situation where they're receiving care, that person could possibly assist that person by making an NDIS application. And in terms of what they can get into the plan review, so again, it might be that there is someone who can support them through that process, who may, if they've granted access, attend a planning meeting, and that could be someone who later acts as a nominee, or is just someone who is supporting a person to provide information to the agency around the types of supports that they need.
Great, thanks, Dom. The next question I think I might be able to answer. So the question from the audience is, can disability advocates help someone to apply for the NDIS? And so I think you may have already covered that, Dom, but the answer to that is yes, they can help. And the Your Story Disability Legal Support Team, as well as Legal Aid New South Wales, works closely with disability advocates. And if it is identified that you do need support with the application process, and less so the legal aspect of the process, we can do warm referrals to those organisations. Or alternatively, as Dom put up in her slide, just a few slides ago,
You're back.
there is the Disability Advocates Finder available on DSS's website. So you can have a look at that if you wanted to find one in your local area. So the next one I think is directed to you, Dom, and it is a member of the audience who said that she has clients with disabilities that can't get social housing. And she would just like an explanation on how the NDIS could potentially pay for accommodation if a person needs disability-specific housing.
So the general concept is that the NDIS don't fund accommodation. They will provide supports to people to facilitate them in the community. And so that's often something we call SIL, like drop-in supports. There is, I guess, we know people with disabilities in social housing and they receive NDIS supports, but they're two different systems, the housing and the NDIS system. There is such a thing as SDA or specialist disability accommodation, but there are quite comprehensive rules around the accommodation being something that a person requires for their disability. So it's because it has modifications and it's built specific for certain types of disabilities. And that's an approval process that you would go through with the NDIS. But unfortunately, it doesn't cover, I guess, a shortfall in social housing. Sure.
Thanks for that, Dom. Got another question directed for you. And the member of the audience is asking, how often do applicants at the AAT have legal representation? They understand that there are strict criteria for Commonwealth funding for those matters. And it feels like the cards are stacked against applicants when they're faced with a legal team from the NDIS or counsel and barristers representing them.
Sure. So I truthfully don't know what the percentage of represented applicants in the tribunal is. But like I mentioned, each state has its own way of assessing and providing legal support to NDIS matters. And from a New South Wales perspective, you can make an application for aid, including representation in the tribunal. And that's assessed, I guess, against guidelines around whether that application is something that is going to assist in the administration of the NDIS or a substantial number of participants under the NDIS, or it's going, the person who's applying experiences a significant disadvantage. So each state will have their own way of assessing who is eligible. In terms of how to, I guess, prepare in a situation where you're in the tribunal and there is a legal representative on the other side, I often find what works is having really comprehensive notes of knowing what you want to say in the tribunal, because it can be really intimidating. So looking at those criteria and using them as your checklist for your evidence, and then writing out, even if it's just by dot points, to make sure that you say everything that you wanted to say and that you get the information across that you want to make across. And if you need something explained, if they're using legal jargon that you don't understand, or they're requesting things that you're not quite sure about, you can always ask for things to be put in writing. You can ask for things to be repeated or explained. In case conferences, you can ask the registrar, if you feel like the representative might be using a lot of legal language, the registrar often will, is a good point to sort of say, look, I'm struggling to understand the legal language, and they facilitate the conversation between the two sides.
Sure. Thanks for that, Dom. And I'm just following up from that, Dom, just on this and the previous question. Look, in terms of getting legal assistance for NDIS related matters, there is a list of all the legal aid commissions available on the Your Story website. And one of my colleagues is going to pop that in the chat. So if that is the legal assistance that you're looking for, have a look and see if you can contact your state's legal aid to get assistance for that. So I might just go back to some of the other questions that we have. So Dom, the next question from the audience is, how is evidence presented at the AAT? Is it unsworn statements and reports? Are they affidavits, or does it have to be sworn evidence?
It depends on, I guess, where you're up to in the AAT proceedings. Often when you're going through the case conference and the conciliation process, you can provide your reports as you receive them from the practitioners or the experts, and you file them online with the AAT, and often you email a copy to the other side as well. So they're not, they don't need to be in the form of a sworn affidavit. What I guess is good practice, and what the NDIA, if they have solicitors, will do, or a legal representative they're involved will do, is if they've asked someone to write a report, they will also include that letter explaining, we've requested you to provide a report. These are the questions we'd like you to answer. And with that, provide the AAT's guideline on providing expert and opinion evidence. And that just, I guess, explains to the person that's providing a report their duties to the tribunal, to assist the tribunal, and to act in an impartial way. If you're in a hearing and someone is giving oral evidence, you'll either be asked to take evidence on oath or affirmation, and that's up to you depending on what you feel comfortable, and same with any person that gives evidence, including experts, they'll be asked. So at that point, it does, I guess, become sworn evidence, but for a conciliation or a case conference, you can provide information as you get it from the experts. Sure.
Thanks for that, Dom. We've got quite a few more. So the next question for you, Dom, is whether in situations where an applicant has difficulty appearing in crowded places, does the applicant at the AAT have to appear in the proceedings?
It depends on a number of different factors. Those processes that the early AAT processes that we've gone over, the case conferences and the conciliations, they are generally conducted by phone or by video. Conciliations are usually by video, and although there are some parts of the tribunal that are going back to face-to-face, if you feel that you would be more comfortable, it's going to be quite difficult for you or the person that you support to attend a case conference a conciliation in person, you can ask for it to be done by video. I think most of them are being done by video. With hearings as well, following the pandemic, video is a process that a lot of people have become familiar with. So that is something that we see a lot now, is hearings occurring remotely. So that may assist that person that might feel uncomfortable going to the tribunal registry in their local capital city. If a person's required to give evidence, generally applicants, there is an expectation they'll give evidence. There might be different reasons as to why they don't, and that could be because they may not be able to give evidence, or they might be a child, so it's not appropriate. And it might be looking at whether there's someone else, so whether it's a carer or a parent or someone that supports that person who can provide evidence as well. And generally the tribunal is really responsive if you need to give evidence, but you supports around that. So, providing breaks, trying to schedule a time that might suit an applicant better, providing accessibility services, translators, interpreters, and so forth.
Sure. Thanks for that, Dom. We've got a question from the Northern Territory Legal Aid Commission from Darwin, and they just wanted to hear your thoughts about having evidence from independent experts versus evidence from the participants' treating team, who may be better placed to comment on the participants' need, but may have a conflict in terms of receiving funding under the participants' plan.
This is a good question. We get this a lot, and I think often in a hearing, there's both. Often, it's not uncommon for the respondent, being the agency, to ask for expert opinion from someone that's new to the participant. And I guess the key starting point is everyone who gives expert evidence is meant to acknowledge their overriding duty to the tribunal. I think that it's really valuable often to have treating practitioners give evidence because of their familiarity with a person in terms of understanding how they may either respond to a particular support or if it's an access criteria in different situations. And I think the tribunal is assisted by that length of detail and expertise, not only in their subject area, which might be OT or speech, but their expertise in the participant, I think is something that really helps the tribunal. Ultimately, it'll be a matter of weight for the tribunal about whose evidence they prefer. But I don't think that it's, you should rule it out on the basis that there is perceived conflict of interest. I think knowing your expert and asking them questions before the hearing and reading their reports to understand how they may present is important. But I think definitely there is a benefit in practitioners who are familiar. The other thing as well, which can be helpful for treating practitioners to give evidence around, is different resources available in different areas. So not every town in Australia has the same access to the same types of disability services or the same types of equipment. And so what they may be able to inform the tribunal on based on those circumstances could be really valuable that's not available from someone who may have travelled to meet a participant or met them remotely.
Right. Thanks, Dom. So there's just two more questions I think we can get to. The first one, I think I might be able to quickly answer. So it was a follow-up from the question regarding housing previously. And the question was, if it's not the NDIS's responsibility around emergency housing for people with disabilities, but homeless services won't take people with disabilities because it impacts their duty of care, what other options are there for people who are on the NDIS that require emergency housing or short-term housing? And so in answer to that, I guess what we would suggest is it really depends on the individual circumstances. So what I might suggest is, if you are facing this issue, to contact your state's legal aid commission, and the solicitor there can examine the entirety of that situation and give advice specific to your situation as to what avenues are available. Was there anything you would like to add to that, Dom?
No, I think that's right. They're really challenging, but kind of each situation's unique. So getting individual advice would be beneficial.
Sure. And I think we've just got one last one that we can probably squeeze in before we close off. And it's the question to you, Dom, and it's asking, what form can evidence take in the AAT? Does an applicant have to appear in person at the AAT?
No, so evidence often comes in different ways. So there can be, in terms of a document, it might be a letter from a doctor or a therapist or an OT, something like that, that might be answering some really specific questions. It might be a general functional assessment where they use different standardized assessments and compile their results in a report. It could be a personal statement written by either a carer or the participant or the person applying to the scheme, outlining. So it can be in all different shapes. Sometimes it just depends on, I guess, where the issues lie between the parties. Sometimes it can be really helpful to provide breakdowns of support. So in matters around how much care a person might access in a day, often the tribunal is assisted by like an example calendar of a person's week, which sort of outlines when they might be accessing support and the different kinds of ways they might be using their NDIS funding across that week. That can just be, as an illustrative example, quite helpful for the tribunal. In a hearing, often the tribunal will want to hear from an applicant that there might be reasons why that's not appropriate, which I discussed earlier. If someone is really concerned about going to a hearing in person. It might be when it's getting listed, having conversations with the tribunal and seeking the agreement of the agency about whether a video or certain experts or the participant appearing by video for certain parts of the hearing as well might be a good workaround.
Right. Thanks so much for that, Dom. And thanks again for joining us and helping us learn about the NDIS today. As we mentioned, Dom is from Legal Aid New South Wales. So thank you to Legal Aid New South Wales for helping facilitate this webinar today. Now, as many of you may be aware, there's currently a Royal Commission into the abuse, neglect and exploitation of people with disabilities. And there is free legal support that's available for people that want to share their stories and their ideas for change with the Royal Commission. And that's the team that I'm working for, the Your Story Disability Legal Support Team. And you can see our contact details up there on the slide. Now, there is an upcoming public hearing that's running from the 11th to the 15th of July concerning the operation of the NDIS for First Nations people with disabilities in remote and very remote communities. So if you were looking for help in sharing a story in that regard, please get in touch with us and we'll be eager to help. And just to close off, we would love to hear from you in terms of how this webinar went. You can complete our survey by scanning the QR code that's currently on the screen or by following the link that appears on the screen at the end of the webinar. A recording of this webinar will be available on our YouTube channel and our Facebook page. You just have to search for Your Story Disability Legal Support in the search bar. And finally, if this webinar has raised any concerns for you, there is free counselling available. You can call Blue Knot on 1-800-421-468 if you need to speak to anyone about this. Otherwise, thank you so much for joining our webinar today. And thank you once again to Dom and Legal Aid New South Wales for helping facilitate this